Hello everyone, welcome back to our channel. Today, we're delving into a crucial and serious topic that demands our attention. Crimes against humanity, war crimes, and genocide. Before we start, don't forget to subscribe and hit that notification bell to stay updated. Now, let's jump right in. Whenever we discuss the contemporary world, global order, and geopolitics, brutal state formation, autocratic and dictatorial regimes, and the struggles for basic human rights, the concepts of crimes against humanity, war crimes, and genocide inevitably come into play. These atrocity crimes represent some of the gravest violations of international law, each with distinct yet interconnected characteristics that reveal the depths of human suffering and the immense stakes of accountability. Crimes against humanity involve systematic and widespread acts directed at civilians, such as murder, enslavement, and torture, within conflicts or oppressive regimes. War crimes encompass breaches of the laws of war during armed conflicts, including the targeting of civilians and the use of prohibited weapons. Genocide, a uniquely heinous crime, involves the intentional and systematic destruction of a specific racial, ethnic, religious, or national group. Addressing these crimes requires international scrutiny, accountability, and justice mechanisms to prevent impunity and uphold human rights. Join us as we examine the framework for a more just world. Let's delve into each of these crimes individually to understand their gravity and implications for humanity. First up, crimes against humanity. Originating from events like slavery and colonial atrocities, this term has evolved through international law. The 1998 Rome Statute defines these crimes. The term has an ambiguous origin, with some scholars tracing it back to the late 18th century in the context of the slave trade. Others point to the 1915 declaration by Allied governments condemning the mass killing of Armenians in the Ottoman Empire as the term's origin. Over time, the concept evolved through decisions of international courts, including the ICC, the ICTY, and the ICTR. The 1998 Rome Statute represents the latest international consensus, providing a comprehensive list of specific acts that constitute the crime. According to Article 7, a crime against humanity involves acts committed as part of a widespread or systematic attack against any civilian population. The listed acts include murder, extermination, enslavement, and the deportation or forcible transfer of a population. It also includes imprisonment, torture, and various forms of sexual violence of comparable gravity. Persecution against any identifiable group on political, racial, ethnic, or religious grounds is also a major component. Additionally, it covers enforced disappearance of persons, the crime of apartheid, and other inhumane acts causing great suffering. Crimes against humanity do not require a connection to an armed conflict and can occur in peacetime, similar to genocide. The definition of the crime includes three key elements: a physical element, a contextual element, and a mental element. The physical element encompasses the actual acts like murder or enslavement. The contextual element requires the attack to be widespread or systematic. Finally, the mental element requires the perpetrator to act with knowledge of the attack against the civilian population. Unlike genocide, these crimes do not require specific targeting of a group. Any civilian population can be a victim. Now, let's unravel the intricate concept of war crimes. Emerging in the late 19th century, these violations focus on breaches of the laws of war. The 1949 Geneva Conventions play a central role, outlining grave breaches and serious violations. The International Criminal Court has jurisdiction, emphasizing the importance of accountability for war-related offenses. The concept of war crimes emerged in the late 19th and early 20th centuries with the codification of international humanitarian law. The Hague Conventions of 1899 and 1907 focused on restricting certain means and methods of warfare, while the Geneva Conventions, starting in 1864, centered on protecting individuals, not participating in hostilities. Various international humanitarian and criminal law treaties, as well as customary law, identify and address these violations. The 1949 Geneva Conventions, ratified by all United Nations member states, play a central role, binding on all states. Customary international law applies to both international and non-international armed conflicts, providing protection even in internal struggles. So what is a war crime? The International Criminal Court's jurisdiction is outlined in Article 8 of the Rome Statute, within the context of a plan or policy. Grave breaches of the Geneva Conventions include intentional killing, torture or inhuman treatment, and causing severe suffering or serious injury. Other breaches include unjustified destruction of property and forcing a prisoner of war to serve the forces of a hostile power. Deliberately directing attacks against the civilian population or civilian objects that are not military objectives is a serious violation. It is also a crime to attack personnel, installations, or vehicles involved in humanitarian assistance or peacekeeping missions. The law prohibits employing poison, poisonous gases, and bullets which expand or flatten easily in the human body. Furthermore, conscripting or enlisting children under 15 into armed forces is strictly forbidden under international law. War crimes incur individual criminal responsibility and must occur within the context of an armed conflict, international or non-international. These crimes require a contextual element associated with conflict and a mental element involving intent and knowledge. By upholding these laws, we extend protection to civilians, medical personnel, and humanitarian workers worldwide. Genocide. Moving on to an exceptionally grave crime, genocide. The term genocide was coined by Polish lawyer Raphael Lemkin in 1944, combining the Greek prefix genos, meaning race or tribe, and the Latin suffix side, meaning killing. This term emerged in response to Nazi policies during the Holocaust and historical instances of targeted actions aiming to destroy specific groups. Raphael Lemkin advocated for the recognition and codification of genocide as an international crime. We explore the 8 stages outlined by Gregory Stanton, warning signs that must not be ignored. Genocide was officially acknowledged as a crime under international law by the United Nations General Assembly in 1946 and was codified in the 1948 Convention on the Prevention and Punishment of the Crime of Genocide. This convention, ratified by 149 states, establishes genocide as a crime under customary international law, with a prohibition considered absolute and non-derogatable. Article 2 of the Convention defines genocide as acts committed with intent to destroy, in whole or in part, a national, ethnical, racial, or religious group. This includes killing members of the group, causing serious bodily or mental harm to members of the group, deliberately inflicting conditions of life calculated to bring about its physical destruction in whole or in part, imposing measures intended to prevent births within the group, and forcibly transferring children of the group to another group. The Genocide Convention establishes that the crime may take place in the context of an armed conflict or in a peaceful situation. The latter is less common, but still possible. The same article establishes the obligation of the contracting parties to prevent and to punish. The popular understanding of genocide tends to be broader than the norm under international law. Article 2 contains a narrow definition which includes a mental element, the intent to destroy a national, ethnical, racial, or religious group, and a physical element which includes 5 acts, enumerated exhaustively, such as killing or causing serious harm. The intent is the most difficult element to determine. There must be a proven intent to physically destroy a group. Cultural destruction does not suffice, nor does an intention to simply disperse a group. It is this special intent, or dolus specialis, that makes the crime of genocide so unique. Case law has associated intent with the existence of a state or organizational plan or policy. Victims are deliberately targeted because of their real or perceived membership of one of the 4 protected groups. This means the target of destruction must be the group as such, and not its members as individuals. In 1996, Gregory Stanton outlined 8 stages of genocide based on the model of the Rwandan genocide. These stages are not necessarily linear, but serve as warning signs. Let us see these stages one by one. 1. Classification. This stage involves promoting an us and them attitude, dividing society along ethnic or racial lines. To prevent this, universalistic institutions that transcend divisions should be introduced, promoting common religion or language. 2. Symbolization. During this stage, the targeted group is further polarized through symbols like group identifiers. Combating this involves personal and state refusal to implement symbols and legal prohibition of hate symbols in speech. 3. Dehumanization. Perpetrators equate the targeted group to subhuman status, facilitating the acceptance of violence. Hate speech must be culturally unacceptable, and leaders inciting genocide should face condemnation without diplomatic immunity. 4. Organization. The perpetrating power initiates preparations for violence, sometimes through informal or decentralized means. Outlawing membership in militias and imposing arms embargoes can combat this stage. 5. Polarization. The majority group is distanced from the targeted group through extremist propaganda and divisive laws. Preventive measures include providing security for moderate leaders and opposing coups by extremists through international sanctions. 6. Preparation. Final preparations are made, including identifying victims, segregating them, and confiscating their property. A genocide emergency must be declared with armed international intervention and humanitarian assistance organized by the UN. 7. Extermination. This is the stage where genocide officially begins, often involving armed forces working with militias. Rapid and overwhelming armed intervention is necessary, establishing safe areas or refugee escape corridors. 8. Denial. After the violence, the perpetrating power denies or hides its involvement, destroying evidence and blaming the victims. Punishment through an international tribunal or national courts is crucial to counter denial and hold perpetrators accountable. Now, let's dive into the horrifying tools used in genocides. The UN Convention identifies specific instruments. 1. Mass killing. Large-scale systematic murder with the intent to destroy a group, often carried out by military or militias. 2. Sexual violence. Perpetrated to intimidate and dehumanize victims. It may be systematic or condoned by leaders. 3. Concentration camps and detention centers. Used to detain members of the group, restricting resistance and facilitating control. 4. Forced abortions, prevention of births, and transferring of children. Methods to restrict the growth of the victim population. 5. Forced deportations and cleansing. Involves removing a group from an area, often coupled with mass violence. 6. Cultural repression. Repression of culture, religion, or language, including the destruction of monuments. These instruments highlight the diverse ways in which genocide can be perpetrated, extending beyond mass killings. Understanding these legal frameworks is the first step toward a more just world. Thank you for watching. See you in the next video.